Hi, I'm Shawn Eyestone from Eyestone Law Offices. Today I'm going to talk to you a little bit about how blended family estate planning is different from a regular nuclear family with husband and wife still married and all of the children being their children. So when you have stepchildren and step-parents involved, the statute treats them differently. So as soon as somebody passes away, so if the husband passes away, his children are beneficiaries of his estate to an extent, and it's set by the statute. And then the wife is a beneficiary to an extent, and it's set by the statute. If you want to opt out of that, you would need to have a will or a trust that says, I want these things to be taken care of in a different way. The same with powers of attorney. There's different people who are able to care for your children under the statute, and you can set that up so that it varies from the statute. For purposes of making life-ending type decisions, your stepchildren, if you're the closest to them and not to your children biologically, you'd want to make sure that you name the stepchildren to have that authority, otherwise they wouldn't. And then the second thing is when you have a blended family, when somebody passes away, if you leave everything to the spouse, you're kind of cutting out the children and you're just leaving it up to the spouse to take care of them. Sometimes we can handle this by requiring a prenuptial agreement, putting some limits around what funds can be spent, and sort of setting aside some funds for the children. So depending on what your circumstances are, there's lots of different ways to handle it. Most people will punt and choose the easiest way, but a lot of times that will get people into trouble after the first spouse passes away.